I never thought I would spend a random Tuesday morning in Phoenix, Arizona, arguing with a woman named Patricia about fire hydrants. But life has a funny way of throwing curveballs when you least expect them. My name is Xavier Zimmerman, and I have been living in the Sagebrush Heights community for 3 years now, minding my own business, maintaining my property, and generally trying to avoid the nightmare that is our homeowners association. That plan went out the window the moment Patricia Newberry, the HOA president, knocked on my door with a clipboard and an expression that could curdle milk. "Mr. Zimmerman," she said, her voice dripping with artificial sweetness, "we need to discuss the fire hydrants on your property." I blinked at her, genuinely confused. "Fire hydrants? You mean the ones the city owns that happen to be near my property line?" Patricia's smile tightened. "According to our HOA bylaws, Section 12, Subsection 4, property owners are responsible for maintaining clear access to all community safety equipment within 50 feet of their property boundaries." I leaned against my doorframe, already feeling a headache forming. "Patricia, those hydrants are on public easements. The city maintains them. The bushes you planted are blocking them," she snapped, her fake pleasant tone evaporating. "You have 72 hours to clear the vegetation, or you will be fined $500 per day until compliance is achieved." I looked past her toward the street. The 2 fire hydrants in question were indeed partially obscured by the Arizona rosewood shrubs I had planted last spring, but they were hardly inaccessible. The shrubs were ornamental, maybe 3 feet tall, and the hydrants were still completely visible and reachable. This was clearly another power trip. "Let me get this straight," I said slowly. "You want me to remove landscaping that I paid $2,000 to install because you think it might possibly interfere with fire hydrants that the Phoenix Fire Department has never complained about?" 72 hours, Mr. Zimmerman." Patricia turned on her heel and walked back to her white Lexus, leaving me standing in my doorway, absolutely fuming. I went back inside and immediately called my friend Derek, who worked as a fire inspector for the city. After explaining the situation, he laughed so hard I had to hold the phone away from my ear. "Xavier, man, that is ridiculous," he said between chuckles. "Those hydrants are city property. Your HOA has zero authority over them. And if your shrubs were actually a problem, we would have already cited you ourselves. We inspect that area quarterly." "Can you give me that in writing?" I asked, already typing it up. "I will email it to you in 10 minutes." True to his word, Derek sent me an official letter on Phoenix Fire Department letterhead stating that my landscaping posed no obstruction to fire hydrant access, and that the department had no concerns regarding the vegetation in question. I printed 3 copies and felt a small surge of satisfaction. But I knew Patricia. She was not the type to back down just because she was wrong. The woman had been HOA president for 6 years and treated the position like she was running a small dictatorship. She had fined people for having the wrong shade of beige on their mailbox posts. She had tried to ban one family from parking their Tesla in their own driveway because she did not like electric vehicles. She once attempted to force a neighbor to remove a wheelchair ramp because it was not mentioned in the original architectural plans, even though it was legally required for his disabled daughter. The next morning, I found a formal violation notice taped to my front door. It reiterated the 72-hour deadline and included photos of my property with the supposedly offending shrubs circled in red marker. At the bottom, Patricia had handwritten, "Failure to comply will result in the HOA taking corrective action at the owner's expense." That last line made my blood run cold. I had heard stories about HOAs hiring contractors to fix violations, and then billing homeowners thousands of dollars with built-in markups and fees. I needed to get ahead of this. I scanned the violation notice and the fire department letter, then composed a detailed email to the HOA board. I addressed it to all 5 members, not just Patricia, and explained the situation clearly. I attached Derek's letter and cited the relevant city codes that established the fire hydrants as municipal property outside HOA jurisdiction. I ended the email with a polite but firm statement that I would not be removing the landscaping, and that any attempt to do so without my permission would be considered trespassing and property damage. The response came back within an hour, but only from Patricia. The other 4 board members were mysteriously silent. "Mr. Zimmerman, your insubordination has been noted. The HOA board voted unanimously to proceed with enforcement. You have 48 hours remaining." I called an emergency meeting with a real estate attorney named Lisa Kowalski, who specialized in HOA disputes. Her office was in downtown Phoenix, a sleek building with glass walls and expensive modern art. Lisa was in her early 40s, sharp as a tack, and known for eating incompetent HOA boards for breakfast. "Let me see everything," she said, gesturing to the chair across from her desk. I handed over the violation notice, the email chain, Derek's letter, and copies of the HOA bylaws. Lisa read through everything with the focus of a hawk spotting prey. After about 15 minutes, she looked up with a slight smile. "This is arguably one of the stupidest things I have seen an HOA try to pull, and I have seen a lot," she said. "They have zero legal standing. Fire hydrants are municipal infrastructure. They cannot enforce anything related to them. So what do? You send them a cease and desist letter. I will draft it right now. If they proceed with any action against your property, they will be opening themselves up to a lawsuit for property damage, harassment, and abuse of authority. And Xavier, if they are dumb enough to actually hire someone to remove your landscaping, you need to document everything. Photos, videos, witnesses, the whole 9 yards. Lisa's cease and desist letter was a thing of beauty. 3 pages of legal language that politely but firmly explained exactly how wrong the HOA was and what consequences they would face if they continued. I had it sent via certified mail and emailed copies to the entire board. 48 hours came and went. I spent the weekend watching my front yard like a hawk, but nothing happened. I started to think maybe Patricia had finally realized she was beaten. I should have known better. Monday morning, I left for work at my engineering firm around 7 in the morning. When I came home at 6 that evening, my Arizona rosewood shrubs were gone. Not trimmed, not relocated, completely ripped out of the ground, leaving gaping holes in my carefully designed landscaping. The irrigation system I had installed was torn up, pipes jutting from the dirt like broken bones. My lawn was torn to shreds from whatever equipment they had used. I stood in my driveway, staring at the destruction, feeling rage build in my chest like a pressure cooker. This was thousands of dollars in damage. This was someone coming onto my property without permission and destroying my landscaping over a petty power play about fire hydrants that were not even the HOA's concern. I pulled out my phone and started documenting everything. Photos from every angle, close-ups of the destroyed irrigation system, wide shots showing the full extent of the damage. Then I called Lisa. "They actually did it," I said when she answered. "They ripped everything out. Do you have documentation?" "Pictures and video, plus I am sure my security cameras caught the whole thing." "Perfect. Go check your cameras right now. I want timestamps and clear footage of whoever did this. I am filing an emergency motion first thing tomorrow morning." My security camera footage was even better than I hoped. Crystal clear video showed a landscaping truck arriving at 9 in the morning, less than 2 hours after I had left for work. Two guys got out and spent 30 minutes completely demolishing my landscaping. But the best part was the last few seconds of footage, where Patricia herself pulled up in her Lexus, inspected the work, nodded approvingly, and handed what appeared to be cash to the workers. I sent the footage to Lisa immediately, along with detailed photos of the damage. Then I did something Patricia probably was not expecting. I filed a police report for criminal trespassing and property destruction. The Phoenix Police Department sent an officer to my house within an hour. Officer Ramirez was a stocky guy in his 30s who looked genuinely annoyed when I explained the situation and showed him the footage. "HOA disputes," he muttered, shaking his head. "We get these calls more often than you would think, but this is pretty clear-cut trespassing and property damage. I will file the report and pass it along to our Property Crimes Division." "What are the chances anything actually happens?" I asked. "With video evidence this clear, pretty good, actually. The district attorney has been cracking down on HOA overreach lately. There was a case last year where an HOA president was actually charged with criminal mischief for similar behavior. That gave me a small spark of hope. But I was not going to wait around for the criminal justice system to maybe possibly do something eventually. I wanted justice now, and I wanted Patricia and her HOA cronies to pay for what they had done. The next morning, I took a personal day from work and met Lisa at the Maricopa County Superior Court. She had filed an emergency motion for a temporary restraining order against the HOA, along with a lawsuit seeking damages for property destruction, harassment, and emotional distress. The amount she was asking for made my eyes water, $50,000. "That seems like a lot," I said nervously. "It is not just about the landscaping," Lisa explained. "It is about punitive damages. We want to make sure they never do this to anyone else. Plus, we are going to argue that they acted with malicious intent, which opens up additional penalties." The emergency hearing was scheduled for that afternoon. I was shocked at how fast the system could move when a competent lawyer was involved. We arrived at the courthouse at 2 in the afternoon, and I was even more shocked to see Patricia show up without a lawyer, just carrying a folder of papers and looking supremely confident. Judge Margaret Holloway was a stern woman in her 60s who looked like she had seen every stupid thing humanity could possibly do and was not impressed by any of it. She reviewed Lisa's motion, then looked at Patricia. "Miss Newberry, you are here representing the Sagebrush Heights HOA." "Yes, Your Honor. This whole situation is a misunderstanding. Mr. Zimmerman was in violation of our community bylaws, and we simply enforced those bylaws as is our right and duty. By trespassing on his property and destroying his landscaping," Patricia's confidence wavered slightly. "We have the authority under the HOA covenants to take corrective action when residents fail to comply with violations. You have the authority to override municipal codes regarding fire hydrants," Judge Holloway asked, her tone sharp. "The fire hydrants are a safety issue for our entire community." "That was not my question. Do you have the authority to override municipal codes?" Patricia stammered. "We have a duty to our residents." Judge Holloway looked at Lisa. "Do you have the fire department letter?" Lisa handed over a copy. The judge read it silently, then looked back at Patricia with an expression that could have frozen lava. "Miss Newberry, not only did you exceed your authority, but you also violated a clear statement from the Phoenix Fire Department that there was no violation. Then you compounded this by trespassing on Mr. Zimmerman's property and destroying his landscaping. Do you understand how serious this is?" But the bylaws clearly state, the bylaws do not supersede city, state, or federal law. I am granting the temporary restraining order. The HOA is hereby prohibited from any further contact with Mr. Zimmerman regarding the fire hydrants or the landscaping. Additionally, I am ordering the HOA to deposit $15,000 into the court registry within 48 hours as a bond against damages while this case proceeds to trial. Failure to do so will result in a default judgment. Patricia's face went pale. Your Honor, the HOA does not have that kind of liquid capital. Then you should have thought about that before you destroyed someone's property. 48 hours, Miss Newberry. Next case. Walking out of that courthouse, I felt vindicated in a way I had not experienced in years. But Lisa put a hand on my arm. Do not celebrate yet. Patricia is going to lose her mind over this, and cornered animals are dangerous. Watch your back. She was right to warn me. That evening, I received an email from the HOA attorney, a sleazy guy named Marcus Roth, who had a reputation for dragging out cases until people gave up or went broke from legal fees. His email was full of legal threats and demanded I drop the lawsuit immediately or face severe consequences. I forwarded it to Lisa, who responded with her own letter pointing out that threatening a plaintiff in an active lawsuit was potentially sanctionable conduct, and that she would be happy to bring it to Judge Holloway's attention if Mr. Roth wanted to continue down that path. The threats stopped after that, but Patricia found other ways to make my life difficult. Suddenly, I was receiving violation notices for everything imaginable. My trash cans were visible from the street for 12 minutes after pickup violation. My front door was the wrong shade of brown violation. My mailbox post had a minuscule scratch in the paint violation. Each violation came with a $50 fine. I documented everything and forwarded it all to Lisa, who added harassment to our lawsuit. But it was exhausting. Every day brought some new petty attack, some new attempt to make me miserable enough to give up and move away. Then I had an idea. If Patricia wanted to play games with fire hydrants, I would show her exactly how expensive that game could be. I did some research into professional fire hydrant maintenance and discovered that it was actually a specialized service. Fire hydrants needed to be inspected, flushed, painted, and maintained regularly. The city contracted this work out to private companies, and those companies charged significant fees. I happened to have a contractor's license from my side business, doing residential engineering consultations. With a little paperwork and a consultation with Derek at the fire department, I established myself as a certified fire hydrant maintenance contractor. It took 2 weeks and about $500 in fees and insurance, but suddenly, I was legally qualified to perform fire hydrant maintenance services. Then I sent an invoice to the Sagebrush Heights HOA. The invoice was a masterpiece of bureaucratic creativity. I billed them for every single thing that had happened since Patricia first showed up at my door. Consultation regarding fire hydrant access, $500. Professional assessment of hydrant visibility, $750. Vegetation management services, forced removal, $3,000. Emergency landscape restoration, $4,000. And then, the piece of resistance. Ongoing fire hydrant monitoring and maintenance services, billed quarterly at $1,200 per hydrant for the 2 hydrants near my property. The total came to just over $8,000 for past services, plus a recurring quarterly charge of $2,400 for ongoing maintenance. I sent the invoice via certified mail to the HOA and copied the entire board. along with a detailed letter explaining that since they had taken such a profound interest in fire hydrant maintenance and had gone so far as to destroy my property over concerns about hydrant access, they were clearly acknowledging responsibility for hydrant maintenance. As a licensed contractor providing those services, I was entitled to fair compensation. The letter also pointed out that by their own actions, they had established a precedent that hydrant access was an HOA concern, which meant they could not suddenly claim it was not their responsibility now that bills were involved. And since the city required regular hydrant maintenance, and they had inserted themselves into that process, they were now liable for ensuring that maintenance occurred. It was beautifully convoluted logic, held together with just enough legal reasoning to be plausible, and I knew it would drive Patricia absolutely insane. Her response came within 3 days, and it was even better than I had hoped. "Mr. Zimmerman, your fraudulent invoice is rejected in its entirety. The HOA will not pay 1 cent for services we never requested and do not need. This is a transparent attempt at extortion, and we will be reporting you to the Arizona State Contractors Board." I forwarded her email to Lisa, who literally laughed out loud when she read it. "Oh, this is beautiful," she said. "She just fell directly into your trap. By claiming the services are fraudulent and unnecessary, she is implicitly admitting that fire hydrant maintenance is not an HOA concern, which directly contradicts her entire justification for destroying your landscaping. So what do? We amend our lawsuit to include your invoice as additional damages. Then, we ask the judge to force the HOA to either pay the invoice or formally admit that fire hydrants are not their responsibility, which would prove their actions were completely unjustified. The amended lawsuit was filed the next day. I also responded to Patricia's threat about the Contractors Board with my own letter, pointing out that I was fully licensed and insured, that my invoice was based on standard industry rates, and that reporting me for billing services related to work they had specifically demanded would constitute retaliatory action, which was illegal under Arizona contractor protection statutes. Marcus Roth, the HOA attorney, finally woke up and realized his client was in serious trouble. He filed a motion to dismiss the case, arguing that HOA business judgment protection shielded the board from liability. Judge Holloway scheduled a hearing for 2 weeks later. During those 2 weeks, something interesting happened. I started getting calls and visits from other Sagebrush Heights residents. Apparently, word had spread about my lawsuit, and people were coming out of the woodwork with their own horror stories about Patricia and the HOA board. There was Jennifer, a single mom who had been fined $1,500 because her daughter's pink bicycle was visible in their front yard for more than 30 minutes. There was Robert, a retired veteran who had been threatened with foreclosure over a dispute about his flagpole height. There was Michelle, whose daughter's lemonade stand had been shut down with threats of legal action for operating an unpermitted business. I collected all of their stories and passed them along to Lisa. She grinned like a shark smelling blood. "This is perfect. We are going to request class action status. If we can show a pattern of abuse and harassment, the judge might decertify the entire HOA board." The hearing arrived, and this time Patricia showed up with Marcus Roth beside her. The courtroom was surprisingly packed. At least 20 other Sagebrush Heights residents had shown up, and I recognized most of them as people who had reached out to me with their own complaints. Judge Holloway noticed the crowd immediately. "This is quite the audience for an HOA dispute." Lisa stood. "Your Honor, the community interest reflects the widespread impact of the HOA's actions. We have filed a motion to amend this case to class action status, as we have documented over 30 incidents of similar abuse and overreach by this HOA board. Marcus Roth jumped up. Your Honor, this is a transparent attempt to inflate a simple property dispute into something far larger. The HOA acted within its authority under the community covenants, and Mr. Zimmerman is simply a disgruntled homeowner trying to avoid legitimate fines. Then explain the fire department letter, Judge Holloway said. Explain why your client destroyed Mr. Zimmerman's property over fire hydrants that the city's own fire department said were not obstructed. The HOA has a duty to be proactive about safety concerns. By ignoring the actual safety experts and destroying property, Mr. Roth, I am not impressed with your arguments, and I am very interested in these allegations of a pattern of abuse. She looked at Lisa. Your class action motion is granted. We will schedule a full evidentiary hearing for 6 weeks from now. In the meantime, the temporary restraining order remains in effect, and I am extending it to prohibit the HOA from issuing any fines or violations to any Sagebrush Heights resident without first obtaining written approval from their attorney. Any violation of this order will result in contempt charges. Patricia looked like she had been slapped. The crowd behind me started whispering excitedly. Marcus Roth tried to object, but Judge Holloway cut him off. Mr. Roth, your client has demonstrated a pattern of reckless behavior. This order is necessary to protect the community while we sort out exactly what has been happening. Do you understand? Yes, Your Honor, he said through gritted teeth. Walking out of the courthouse, this time felt even better. Jennifer, Robert, Michelle, and at least a dozen other residents surrounded me in the hallway, thanking me and asking questions. Lisa took charge, handing out her business cards and scheduling consultations. But my favorite part was watching Patricia storm past us all, her face purple with rage, while Marcus Roth tried to calm her down. She looked directly at me for just a moment, and the hatred in her eyes was so intense I actually took a step back. This is not over, she hissed. You are right, I said calmly. It is not. See you in 6 weeks. Over the following month and a half, the situation escalated in ways I could not have predicted. Lisa worked with nearly 40 residents to document their complaints against the HOA. The stories ranged from annoying to outright horrifying. One elderly couple had nearly lost their home to foreclosure over a dispute about the color of their window shutters. A young family had been fined $10,000 for installing a playground in their backyard without architectural approval, even though their property backed up to a desert wash where no neighbors could see it. But the worst case was a woman named Sandra, whose disabled son required a service dog. Patricia had tried to ban the dog from the community, claiming it violated pet size restrictions, despite the fact that service animals were explicitly protected under federal law. The stress had been so severe that Sandra's son had ended up hospitalized with anxiety attacks. Lisa built our case like a prosecuting attorney preparing for a murder trial. She had spreadsheets, timelines, financial analyses showing where HOA funds had gone, and expert testimony lined up from HOA management professionals who would explain exactly how badly Patricia had failed in her duties. I, meanwhile, had sent a second invoice to the HOA for my ongoing quarterly fire hydrant monitoring services. Patricia sent back a response that was just 2 words: "Get lost." I added that to the evidence pile. The really interesting development came about 4 weeks before our hearing. Officer Ramirez called me and asked if I could come down to the police station to answer some follow-up questions about my property damage report. When I arrived, I was surprised to find a detective waiting instead. Detective Sarah Morrison was a sharp-eyed woman in her 40s who specialized in financial crimes. She invited me into an interview room and pulled out a thick folder. "Mr. Zimmerman, your property damage report got flagged by our fraud division. We have been investigating your HOA for potential embezzlement." "Embezzlement?" I said, surprised. "Your case was not the first complaint we have received about Sagebrush Heights. 3 other residents filed reports in the last 2 years about suspicious fines and fees." When we started digging into the HOA's financial records, we found some very interesting discrepancies. She spread out several documents on the table. They showed HOA bank statements, expense reports, and vendor invoices. "Your HOA collects about $300,000 annually in dues from the 260 homes in your community. That money is supposed to go toward landscaping, pool maintenance, security, and general community upkeep. But in the last 3 years, over $150,000 has disappeared into vague expense categories with no supporting documentation." "Where did it go?" I asked. "That is what we are trying to figure out, but here is what caught our attention." She pointed to a specific invoice. "Remember those landscaping contractors who tore up your yard? They do not exist. The company name on the invoice is registered to a P.O. box. The phone number is disconnected. We think Patricia hired someone under the table, paid them in cash, then created a fake invoice to justify the expense." "Can you prove it?" "We are working on it. But here is where you can help. Your lawsuit is going to force the HOA to produce detailed financial records. Once those are in the court system, we can subpoena them for our criminal investigation. The more evidence your attorney uncovers, the stronger our case becomes." I left the police station with my head spinning. Patricia was not just a petty tyrant. She was potentially a criminal. This changed everything. I told Lisa about the detective's visit and her eyes lit up. "This is even better than I thought. If there is criminal activity involved, we can push for piercing the corporate veil and going after Patricia personally, not just the HOA." "What does that mean?" "It means she could lose her personal assets, her house, her car, her savings. Everything." The evidentiary hearing finally arrived on a Thursday morning in late March. The courtroom was packed with at least 50 Sagebrush Heights residents, plus news reporters from 2 local TV stations. Apparently, our case had attracted media attention. One of the reporters had done a whole segment on HOA abuse, featuring interviews with several of my neighbors. Patricia arrived with Marcus Roth and 2 other attorneys, a clear sign she was taking this seriously now. She looked haggard, like she had not slept in days. "Good." Judge Holloway called the court to order and looked at the crowd. "I see this case has generated significant public interest. Let me be clear, this is a civil hearing, not a circus. Anyone who disrupts these proceedings will be removed. Understood?" Everyone nodded silently. Lisa presented our case first. She called witness after witness, each one telling their story of HOA abuse. Jennifer and her daughter's bicycle, Robert and his flagpole, Sandra and her son's service dog, Michelle and the lemonade stand. The testimony went on for 3 hours, and by the end, even the judge looked angry. Then Lisa presented the financial analysis. A forensic accountant took the stand and walked through the HOA's books, highlighting expense after expense that made no sense. Landscaping bills that were triple the market rate, security costs for services that did not exist, maintenance fees for equipment the community did not own. "In my professional opinion," the accountant said, "this HOA has been mismanaged to the point of potential fraud. At least $150,000 in expenses cannot be verified or justified." Marcus Roth cross-examined aggressively, trying to poke holes in the testimony, but the damage was done. When it was his turn to present Patricia's defense, he called her to the stand. "Miss Newberry, can you explain your decision to remove Mr. Zimmerman's landscaping?" "It was a safety issue," Patricia said, her voice tight. "The fire hydrants needed to be accessible and his bushes were blocking them." "Even though the fire department said they were not," Lisa interjected. "Objection, she is not cross-examining yet," Marcus said. "Sustained, but I want to hear the answer," Judge Holloway said. "Miss Newberry, how do you justify ignoring the fire department's assessment?" Patricia faltered. We felt it was necessary to be proactive. By destroying someone's property without permission, we had the authority under the covenants. You have the authority to override municipal officials. I was trying to protect the community." Judge Holloway leaned forward. "Miss Newberry, let me ask you something else. Where did the HOA's money go? Can you account for the discrepancies in your financial records?" Patricia's face went pale. We have receipts for everything." "Then I am sure you will have no problem providing them." "I am ordering the HOA to produce complete financial records going back 5 years, including all bank statements, invoices, receipts, and vendor contracts. You have 2 weeks." Marcus Roth tried to object, but Judge Holloway shut him down immediately. "Mr. Roth, your client has been accused of financial mismanagement and potentially worse. If she has nothing to hide, the records will prove it. If she refuses to produce them, I will draw appropriate inferences." The hearing adjourned, and Lisa grabbed my arm excitedly as we left the courtroom. "Did you see her face? She is panicking. I bet you anything she cannot produce those records because they do not exist or because they prove fraud." 2 weeks later, the HOA filed an emergency motion requesting an extension to produce the financial records. They claimed their accountant was on medical leave, and they needed more time to organize everything. Judge Holloway denied the motion and gave them 48 hours. When the deadline came, the HOA produced a box of disorganized papers that looked like someone had dumped a filing cabinet into it randomly. There were receipts with no corresponding invoices, invoices with no receipts, bank statements with redacted information, and dozens of expenses marked simply as miscellaneous community services. Lisa took one look at the mess and filed a motion for sanctions, arguing that the HOA was deliberately obstructing discovery. Judge Holloway agreed and fined the HOA $10,000, payable immediately. That same week, Detective Morrison called me again. "We executed a search warrant on Patricia Newberry's home and office yesterday. You are not going to believe what we found." "What?" "She was running a shell company. For years, she has been billing the HOA for services from fake vendors, paying herself with cash withdrawals, then using fake receipts to cover it up. We found over $200,000 in falsified invoices in her home office. She has been embezzling from the HOA since she became president." $200,000, I said, stunned. "At least. We are still sorting through everything, but it looks like she was also taking kickbacks from legitimate vendors, inflating expense reports and skimming money from the community pool fees." "What happens now?" "We are filing criminal charges. Grand theft, fraud, embezzlement, forgery. She is looking at serious prison time if convicted." I sat down heavily on my couch, trying to process everything. Patricia was not just a power-hungry HOA president. She was a thief who had been stealing from her neighbors for years. The news broke the next day. Local TV stations ran stories about the HOA president arrested for embezzlement. Patricia's mugshot was all over the internet, her face a mask of rage and humiliation. The Sagebrush Heights community erupted in chaos. Residents were furious, demanding answers, calling emergency meetings, threatening lawsuits. The remaining HOA board members tried to distance themselves from Patricia, claiming they had no idea what she was doing. Detective Morrison told me that was probably true. Patricia had kept the financial records tightly controlled, never sharing full details with the other board members. Our civil lawsuit moved forward despite the criminal charges. Lisa argued that the HOA as an entity was still liable for Patricia's actions, since she had been acting in her official capacity. Marcus Roth tried to argue that Patricia's criminal behavior absolved the HOA of responsibility, but Judge Holloway was not buying it. The HOA board had a fiduciary duty to oversee their president's actions, the judge said. Their failure to detect or prevent years of embezzlement constitutes gross negligence at minimum. The final judgment came down in late May, almost 6 months after Patricia had first knocked on my door demanding I clear the fire hydrants. Judge Holloway ruled in favor of the plaintiffs on every single count. The HOA was ordered to pay $280,000 in damages, divided among the 40 residents who had joined the class action. My share was about $18,000, which more than covered my destroyed landscaping and legal fees. But the real victory was the court's additional orders. The HOA board was decertified and disbanded. A court-appointed receiver would manage community affairs until new elections could be held with proper oversight. All existing fines and violations from the previous board were voided, and the HOA was required to implement new bylaws with strict financial controls and transparency requirements. Patricia's criminal trial happened in September. I attended every day, sitting in the gallery with dozens of other Sagebrush Heights residents. The prosecution presented overwhelming evidence of her fraud. Bank records, falsified invoices, testimony from handwriting experts, digital forensics showing she had created fake vendor companies. Her defense attorney tried to argue that she had meant to pay the money back, that it was just temporary borrowing, but nobody believed it. The jury deliberated for less than 4 hours before returning guilty verdicts on all 23 counts. Judge Harold Martinez sentenced Patricia to 8 years in prison, followed by 5 years of probation. She was also ordered to pay full restitution to the HOA, though nobody expected she would actually be able to come up with $200,000. The judge made a point of addressing her directly. "Miss Newberry, you held a position of trust in your community. People relied on you to manage their collective resources responsibly. Instead, you stole from your neighbors systematically over many years. You used your authority to intimidate and harass anyone who questioned you, and when finally confronted with your misdeeds, you continued to lie and obstruct justice. I have no sympathy for you." Patricia broke down crying as bailiffs led her away in handcuffs. I felt no satisfaction watching her cry, just exhaustion and relief that it was finally over. The story did not quite end there, though. Remember my invoice for fire hydrant monitoring services? I had sent it as a joke, a way to throw Patricia's own logic back in her face. But something funny happened. The court-appointed receiver who took over HOA management actually called me about it. "Mr. Zimmerman, I am reviewing all outstanding HOA obligations, and I came across your invoice for fire hydrant services. Can you explain this?" I explained the whole situation, assuming he would laugh and tell me to forget about it. Instead, he surprised me. "You know what? You actually have a legitimate argument here. The previous board did destroy your property specifically because of fire hydrant concerns. They inserted the HOA into municipal infrastructure management, at least in their own minds. And you are a licensed contractor who could legitimately provide those services. I am going to recommend the HOA settle this by paying your past services invoice in full and signing a contract for ongoing monitoring. Are you serious? I asked. Completely. It will cost the HOA far less to pay your invoice than to fight it in court, and frankly, having someone actually monitor those hydrants is not a bad idea. The city only inspects them quarterly. You could do monthly visual checks, keep vegetation trimmed, report any issues immediately. It is a reasonable service for a reasonable price. 3 weeks later, I received a check for $8,000 covering my past services invoice. I also signed a 3-year contract with the HOA to provide monthly fire hydrant monitoring at $1,200 per hydrant per quarter. That works out to $9,600 per year, for about 2 hours of work per month. Patricia, sitting in her prison cell, was probably losing her mind knowing that her attempt to bully me over fire hydrants had resulted in me being paid by the HOA forever to monitor those same hydrants. The new HOA board, elected in November, was a completely different group of people. They included Jennifer, the single mom who had been fined over her daughter's bicycle, Robert, the veteran with the flagpole, and several other residents who had been victims of Patricia's abuse. Their first act was to revoke all of Patricia's stupid rules about mailbox colors and trash can visibility times. Their second act was to enthusiastically approve my fire hydrant monitoring contract, and even asked if I would be interested in providing other community services. I declined, explaining that I already had a full-time job and the fire hydrant work was about all the side work I wanted. But I appreciated the offer. Life in Sagebrush Heights slowly returned to normal. The community pool reopened with proper maintenance. The landscaping was actually maintained by legitimate contractors at reasonable rates. People stopped living in fear of arbitrary fines and violation notices. I replanted my Arizona rosewood shrubs, this time keeping them even further from the fire hydrants just to be safe. They grew beautifully, and every time I water them, I think about Patricia and her clipboard and her artificial sweet voice demanding I clear fire hydrants that were never actually blocked. Derek, my fire inspector friend, still laughs about the whole thing whenever we meet for drinks. He cannot believe I turned a ridiculous HOA power trip into a permanent revenue stream. You know what the best part is, he said one evening. Those hydrants are now probably the most well-maintained in the entire city. You actually check on them more often than we do. He was right. I take my contract seriously, even if it started as a joke. I do monthly visual inspections, keep detailed logs, photograph any issues, and coordinate with the city immediately if something needs repair. In 18 months of monitoring, I have caught 2 potential problems before they became serious. A slowly leaking valve and a hydrant that someone had hit with their car, causing subtle structural damage. The city's fire department actually sent me a letter of commendation for catching that second issue. Derek framed it and gave it to me as a gag gift. It hangs in my garage next to my contractor's license. Sometimes I drive past Patricia's old house. A nice young family bought it after the bank foreclosed. They have kids who play basketball in the driveway, which definitely would have driven Patricia crazy since she had rules about outdoor sports equipment being visible from the street. The kids are loud and happy, and I always wave when I see them. I also drive past the fire hydrants near my property every single day, obviously. They stand there bright red and easily accessible, surrounded by my carefully maintained Arizona rosewood shrubs that never blocked anything in the first place. Those hydrants represent so many things to me now. Patricia's overreach, the corruption that hid behind petty HOA rules, the community that came together to fight back. And yes, the quarterly payments that will keep coming as long as my contract remains in effect. The other residents in Sagebrush Heights have mostly moved on from the drama, though new people moving in always hear the stories eventually. We have become something of a legend in local HOA circles. Real estate attorneys tell our story as a cautionary tale about HOA overreach. A professor at Arizona State University even asked if he could use our case as a teaching example in his property law class. I sometimes wonder what Patricia thinks about, sitting in her prison cell at the Perryville Women's Prison west of Phoenix. Does she regret her actions? Does she understand how her petty power trips destroyed her life? Or does she still think she was right, that she was just trying to protect the community and everyone else was wrong? I will never know. And honestly, I do not care. She made her choices. She stole from her neighbors, harassed people who dared question her, and destroyed property to prove she was in charge. The consequences were entirely her own fault. As for me, my life is pretty good. My landscaping looks great. My relationship with my neighbors is better than ever. I have a nice side income from my fire hydrant monitoring contract. And I learned valuable lessons about standing up to bullies, documenting everything, and not backing down when you are in the right. The fire hydrants near my property will need to be monitored and maintained for years to come. The city has no plans to relocate them. My contract automatically renews unless either party provides 90 days written notice. The new HOA board is happy with my work and has no reason to cancel, which means Patricia's attempt to fine me over fire hydrants will result in the HOA paying me potentially tens of thousands of dollars over the coming years. Every single quarter, when I submit my invoice and receive my payment, I think about her knocking on my door with that clipboard and that condescending smile. I never intended to become a fire hydrant monitoring contractor. I never wanted to sue my HOA. I never asked for any of this drama. I just wanted to live in my house peacefully, with my Arizona rosewood shrubs providing some nice landscaping near the property line. But Patricia could not leave well enough alone. She had to push. She had to prove she was in charge. She had to destroy my property to demonstrate her power. And now she is in prison. The HOA she ran is under new management, and I get paid to monitor the fire hydrants she was so concerned about. Sometimes justice has a sense of irony. And sometimes, when you demand someone clear your hydrants and they send you an invoice, you really should consider just paying it. Because the alternative might be prison, and a lifetime of knowing that your attempt at petty tyranny backfired in the most spectacular way possible. The fire hydrants near my property stand as bright red monuments to Patricia's downfall. They are clean, well-maintained, regularly inspected, and absolutely not blocked by any vegetation. They are probably the best monitored hydrants in the entire Phoenix metropolitan area. And every quarter, the Sagebrush Heights HOA pays me $1,200 per hydrant to keep them that way. I clear their hydrants. They pay my invoice. Forever. It is exactly what Patricia demanded, just not in the way she imagined. And that might be the most satisfying part of this entire story.